All right. Welcome to the Great Trials podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, how are you doing this beautiful day?
I'm good. I'm good, Steve. How are you?
Good. I don't know how Atlanta is, but Savannah's been getting some nice weather. It's like in the 70s. So it's nice to go out for a walk where it's not too hot.
Yeah, this is our first fake fall in Georgia for those who've been living here for a while. This is the first fake fall. We'll have another fake fall, and then it will really be fall.
Right. Yeah, exactly. Exactly.
That's how it goes.
Well, I'm excited for our guest today. We got a great one.
Yes, that's right. We've got Eric Fong on the show today, and there is so much to talk about with this case and about him. So Eric, welcome to the show.
Thank you.
I'm going to tell our listeners a little bit about you, and then we'll get into your case. But for our listeners who aren't familiar with Eric, he's accomplished some very cool stuff, including the case that we're going to talk about today. If you want to look him up, you can look him up at ericfonglaw.com. Eric is based in Washington State in Port Orchard, which is outside of Seattle. And I happen to have been to Port Orchard, which is just only cool because I'm so far away from the West Coast, but I loved it there, Eric. And everything was a novelty to me, including like the ferries and the blackberries growing everywhere. I just had a great time.
It's kind of mystical. I grew up in Indiana, and so to come to a place like this, which we're kind of removed from the city, we're out on the peninsula. And it's
beautiful.
Yeah.
There's so much water, coastline, trees, mountains, canyons, deserts. And of course, Seattle's a world-class city. So
yeah, it was so awesome. I went for a family thing, and my brother was there, and we went to the park, and he could just not get over the fact that there were like blackberries and stuff growing everywhere that he could just eat. He was very into that. He's a bottomless pit when it comes to food. So it worked out well for him. Anyway, so I've told everybody about where you live, but not much else. Eric is a many-time super lawyer from 2011 to the present. He's a top 100 trial lawyer. He's been named Trial Lawyer of the Year by numerous organizations, including the Washington State Trial Lawyers. I guess is it WDTL? No.
Yeah.
Okay.
Yeah.
And the Trial Lawyers College. He's also an instructor for the Trial Lawyers College, and he helps out with the Seattle Clemency Project. So he's done over 100 civil and criminal trials, and he takes a creative approach to cases, and we're going to talk about that today in the case that we're going to talk about. He has many terrific results, including the one we're going to talk about today, a $91 million verdict, which is the largest compensatory damages verdict for one person in Washington State. But I got to ask you before we get into this case, I think you know what I'm going to ask you.
I was wondering when you were going to get there.
I saved it for last.
Yeah, that's right.
I've got to ask about George Clinton. You've got to tell us about this.
Yeah.
George Clinton, he's one of those guys. So I know Jerry Spence really well. He's a mentor of mine. And George Clinton and Jerry Spence so there's a brilliance to these men and a creativity and just like this inner wisdom and voice where you'll just be sitting there and they'll say something that is so profound you don't even know how to react. And so George Clinton is a creative genius. He is an artist that revolutionized. He's the Black Elvis, rap. Right. He's one of the most sampled artists ever. And it was a real privilege and honor to represent just a force of nature. And it was obviously fun.
Yeah.
It was a different time in my life. So
Was it you? I mean, because you did it. It was sort of a copyright issue. Had you been doing a lot of that, or was this more about, this was a person that inspired you that you really wanted to dig in to work for and with him?
That's a good question. How does a Port Orchard lawyer, a city of 8,000 people, end up doing something like that? And somehow he had heard of me. We talked and he liked me and I liked him. And we went down a collaborative road. I assembled an amazing legal team that had copyright experts, that had federal civil procedure experts, which are not my strong suit. And, together we went at it.
Yeah.
That's
Yeah.
awesome.
And you won and made good law.
Yeah, it was
Up through the Ninth Circuit, right?
yeah.
Nice.
Yeah.
That's awesome. Well, let's get into the case we're here to talk about today. I mentioned it was a massive compensatory verdict for an individual, but we'll explain about where that verdict came from and how Eric helped the jury get to where they needed to be. This is a COVID case. So we've had a few, Steve, we've been lucky to talk about a few COVID trials now happening during COVID times.
Yeah.
And this is one of them. The case is William Tisdale versus either Apro LLC or Apro. We'll probably call them Apro. This case was tried in June 2021, but involved an incident that happened in November of 2015. I'm going to talk a little bit about what happened, and then Eric will just dig in. And there's especially some fact-specific questions I have for you that I think would paint a better picture of what happened. But around 11 p.m. on the night of November 4th, 2015, William was a customer at an Apro convenience store in Parkland, Washington. And unbeknownst to William, to Mr. Tisdale, as he's arriving, the clerk who is working in the convenience store, Mr. Baker, he's working there by himself. So he's the only one who's there. And inside the store, what's happening is that he is being threatened by another, I guess we could call him customer, but he wasn't really planning to pay for anything. So maybe he's
Right.
not a customer, named Mr. Sablin. And he had a baseball bat. He had tried to take some cigarettes. There was a discussion I want to get a little more into about what he was doing in the store. But he's threatening the clerk. He wants these cigarettes. He wants money from the register. Mr. Tisdale does not know this. And so he goes to walk in the store, and the clerk tells Mr. Tisdale, Eric's client, to call 911. And I want to get a little more clear on the timing, but at some point during all of this, Mr. Sablin, the guy who's trying to hold up the convenience store, walks outside. So meanwhile, Mr. Tisdale goes outside to call 911, and he sees Mr. Sablin, who was previously in the convenience store trying to get money and cigarettes, at his car, at Mr. Tisdale's car. And so he confronts Mr. Sablin, and Mr. Sablin attacks Mr. Tisdale with a bat, giving him horrible injuries that we're going to talk about: multiple skull fractures, TBIs, which we've talked about on the show many times, retinal damage, and all of this is caught on video. And we'll talk about what Eric was able to do with that. So obviously after these injuries, Eric helps Mr. Tisdale bringing a case against the convenience store company, the company that owned the convenience store, alleging, among other things, failure to have proper security measures and failure to train the clerk, Mr. Baker, in those security measures. So as we mentioned, the case was tried in June 2021 in Pierce County, Washington. And so it involved all the sort of things we've been talking about logistically in terms of bringing a case to a jury during COVID. And we'll talk about that. But despite a lot of hurdles and a lot of last minute trial stuff, I was reading the transcript, and I didn't get through the whole transcript, but there's a lot of good stuff in there. The jury found in favor of Mr. Tisdale. They found Apro, the convenience store company, 90% at fault. They assigned 10% of fault to Mr. Tisdale, and they awarded $91 million in total damages, which I really wanted to leave that for the end, but I also felt like I had to lead with it because it's such a tremendous result. I will stop talking now, Eric. There's so much to talk about, but before we get into some of the strategy questions, I was reading your opening, and I know that you had a video and you were able to do a much better job than I did describing sort of chronologically what the situation was, how Mr. Tisdale got into the situation, and what was really going on.
Well, what's really going on is that convenience stores that are open 24 hours a day are dangerous. and especially convenience stores that are located in certain neighborhoods and areas. And it's a scientific fact that these businesses are going to get robbed and people are going to get hurt. And it's no different than a bar over serving a patron and then giving them the keys and telling them to drive away. That bar has a responsibility to make sure that innocent people out on the roads don't get hurt. And a convenience store that's open 24 hours a day, now it doesn't jump out at you like, a bar getting someone drunk and telling them to drive home, but it's identical because there is a scientific correlation between this business because of what they sell. They're open 24 hours a day, alcohol and cigarettes. And you put them in a neighborhood that is high crime to begin with, they're easy targets. And because of that, the convenience store Apro had an unmitigated duty, a responsibility to address known safety issues. And not only did they not do it, they were almost like either they were ignorant about it that they were supposed to do it because it's a state law.
Right.
To say nothing of the fact that just as a good person, as a good business, if you're going to run a shop, let's try and make it safe for the people we're serving. But they were so defiant about it that it was a dangerous place. Like employees were afraid to work in the store, like it was crazy. It was absolutely a dangerous place.
One of the things that I liked that you did in the opening is that you kind of took the jury through sort of the history of convenience stores, and then when there was a decision to go from, as you pointed out, 7 to 11, 7 in the morning to 11 at night, and then go to 24
I never
hours.
put that together, by the way.
Yeah, exactly.
Never put that together.
I never knew the story of the Southland Ice Company, but that's how 7-Eleven started. But once they made the decision to go to 24 hours, that they noticed almost an immediate uptick in crime, robberies, and people getting injured, and the industry itself was basically studying that issue. So it wasn't like if you owned a 24-hour convenience store, and by the way, Apro is a very large corporation with convenience stores all up and down the West Coast. So it's not like this is a mom and pop or this is their only store that they don't know about. But if you own a 24-hour convenience store, that there is a danger to people that come in there, especially if they come in there late at night when there are more people out who might be willing to do criminal activities.
Yeah, so I'm sorry, related to that, Eric, because I think this might also factor into your answer. In Georgia, if you have something that involves criminal activity, even if you didn't name that person as a defendant, the jury would have the opportunity to allocate fault to that criminal defendant on the verdict form. And so I'm hoping as you talk about this, you can also touch on how that works in Washington or in this case.
Yeah, so I focus group this a lot, as you might imagine. And for those of you that, listen in, a focus group is what Coca-Cola would do to test, a slogan or an ad or taste products. And you learn, kind of the common sense reaction to events. And in my focus group, I found that a lot of people wanted to blame my client because he went up to his car and Yvonne, you mentioned he confronted the robber. He didn't confront the robber. He went up to a person in his car and said, "What are you doing?
Mm-hmm.
What are you doing? That's not your car." But a lot of people, we want to blame other people when bad things happen to them. And the fact of the matter is that what happened to my client was the very danger that the law required them to prevent. And so as a lawyer, if you don't focus group these things, or if you don't understand the dangers that we face and how you frame it, it's a matter of how you explain the story. So if I had started this case out talking about my client, he goes in there and there's someone in his car and he runs up to him and says, "What are you doing?" The first reaction is going to be, "Well, what do you think is going to happen if you go up to a stranger in your car?" A lot of people go there. Now, a lot of people will be like, "Well, what's wrong with that?" Mm-hmm. You have a constitutional right to go defend your car. And frankly, if you don't do that, there's something wrong with you. So I knew what the thinking was behind that reaction. But back up. The bottom line is, if I'm talking about my client and his actions, that's not what this case is about. This case is about a convenience store that put him at risk. They put their employees at risk, and what happened to them is exactly what they knew was going to happen to their customer. And in fact, it had happened just a few weeks before this event, and the police had been called there hundreds of times in the years leading up to this. And so, allocation of fault is of course going to be an issue that they're going to raise on appeal and say, oh, we get to blame all of this on a criminal. How could we have known he was going to do this? Mm-hmm. And unfortunately for Apro, Washington and the definition of responsible parties, I don't even think their lawyers at closing argument understood that in the law in Washington is you do not get to blame an intentional actor if they're not a party, and the risk that was presented was the exact risk that the defendant had a duty to prevent.
Yeah.
Yeah. And I mean, that makes sense, right? If you have this responsibility, this obligation in this law to do something, and then the thing that this law is designed to prevent happens, to just blame it would be awfully circular.
It would be circular. So you go back to the bar that's consistently overserving its customers so it can make a few extra bucks a night. And then the drunk driver gets in the car and drives and kills a family. Should that family, that lost everyone, not be entitled for the huge loss that they had simply because a criminal got behind the car drunk and drove?
Right. Go ahead.
No, it's just, it was an obvious danger point in the case, and they offered nothing. So I got to go into court and try things out. And, obviously, did it all right, did a pretty good job.
Yeah.
A decent job to come at a $91 million verdict.
Yeah.
Honestly, I don't think it was enough.
Right.
The loss that this man and what he's living with, and our valuation of money in Apro, it's $1 billion company. And, our society's valuations of people and just the human worth of what it means to live, we are so ass backwards. And to say that this person isn't worth, some dollar amount, luckily I wasn't afraid to ask for what I thought truly this man is worth. Because if I had my own issues with money, and a lot of people do, it's hard to ask for money because we carry our own insecurities and guilt and, whatever stuff's been layered on us as we grew up. But if I had thought that this man wasn't worth every penny that I had asked for, I would have sold him short, because this jury cared for him. They obviously felt that, he's a worthy human being. And so.
Yeah. Well, and that was clear. I mean, because 91, I mean, that's what you asked for, right? And in your close, and they gave you every penny of that.
Yeah. And I did not think he was at fault for anything, but I said, but what I, in closing argument, because I knew a lot of people would blame him, if you're going to blame the guy because he went up to his car, 10%,
right.
10% for asking someone what they're doing in his car. And they agreed with that too. So, they punished him. They attributed fault to him. They reduced the award by, the verdict by 10%.
Yeah.
Yeah.
So I wanted to ask, just because you did mention how important it is to focus group these issues. When do you start focus grouping, and what did you do in this case? What kind of focus group or groups did you do?
Yeah. So, I mean, when you start preparing for, so when I got this case, my kind of goal in my mind was get past summary judgment, massive damages, tough liability case. It should be a no-brainer to settle for $1 million. Mm-hmm. Like that was when I got the case, and I'm thinking, do I want to do this or not? Because a lot of lawyers wouldn't take this case. And so when I file a lawsuit, you don't really necessarily get a good feeling whether it's going to go or not. This was not a case I wanted to try, because I was obvious to me of the risk in it. So when it became clear the case wasn't going to settle, which took a little bit of time because they dragged their feet and they played a lot of legal games that, we're used to seeing. But when it became really clear that there was just no way they were going to settle, which I would say is a good solid 8 months before in the trial date, there was so much uncertainty because of COVID. I would say about 8 months before I started going all in, like, you know, like anything I could do to try and understand and respect the other side and be afraid of their arguments so that I could unlock the puzzle. And so I did a number of focus groups with a company called Paramount Focus Group, where we got, 12 people from the community, and they spent a lot of time understanding the issues, and we just focus in on that. And then I also did a focus group with empirical jury, I think, a guy by the name of John Campbell. It's extraordinary what he does, but that's like a 500 person focus group.
Yeah.
Oh, wow.
It's pretty intense.
Yeah.
And so there was it was a lot. It was a lot of focus grouping. And then of course, my favorite focus groups are my friends, my family. And I'll show them the video and clients, I mean, like I'll get my, look, because it's so grainy, I'm not betraying any confidences, but I was constantly running this fact scenario, the video, because it's all on video. Yeah. And then I would play around with different ways of describing what happened, and I would see how people react to it.
Yeah. Yeah. I'm glad that you talked about that, and especially how things shift, because I do think that happens a lot in cases where, you're focused on, you're focused on just making sure the complaint has all the elements and is going to, survive a motion to dismiss. And then you're just focused on figuring out what actually happened in discovery. And then, so much of that until you get past like the dispositive motions phase. I know there are people who focus group it early, but there's so many other things that you're trying to do at the same time in that earlier phase of the case versus then after sort of the dispositive motions, or, it kind of flips, and then your focus and your audience and everything it just really changes, because when you're working up a case, you're just thinking a lot of different things. And when I started practicing, especially, that was I had obviously never done that. I had never really gone all the way to trial. And so I had always been thinking about the legal side of things, the motion-y side of things, and not how after that, how things switch and you have to get reactions from people.
So it's two different worlds. So I come from a background of really academic heavy family, like all professors and what have you. And the motions practice and the legal issues is a whole separate part of the brain. The focus and the attention and going down those rabbit holes of ferreting out the legal issues. And then it's like the other side of the brain, the creative kind of curiosity and visualizing and pictures is another skill. I am wholly deficient in that first part, which is kind of black letter law and legal briefing and analysis. But where I can do things, that I'm proud of is connecting at an emotional level of storytelling and from the heart, and making really complicated things really simple.
Yeah.
You know what I mean? So that like when you hear it, you're like, duh. And so one of the things, if you're going to go try a case, I think that you would really like, what are my strengths and what are my weaknesses? And how can I put people around me that just build me up and complement where I'm deficient?
Yeah.
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 So Eric, I wanted to ask you, when you're talking about the focus groups and putting the case together, I do want to point out that from the defense's standpoint, they had, what I think they thought were good defenses and some things that you might have to overcome. Like was there some claim by them that he might have been intoxicated, that your client might have been under the influence of something at the time? Yeah,
the huge claim on that.
Okay.
Which was, first of all, let's be very clear. They lied about that, but my client, they tried to say that he was on opiates and they tried to make a huge thing about his drug addiction and alcohol use. And I, honestly, like before the trial started, I was thinking, I'm going to have these experts prosecuted for perjury.
Right. Yeah.
No, I'm dead serious. I wanted to bring their experts to the attention of the court because what they're doing was so wrong and dishonest. And unfortunately, we see it so often, like the things that people will do for money. Yeah. And that's what's so ironic about this case. Because he's not like, he just wanted to be treated fairly. He just
Yeah.
wanted to be like, give me a little bit of respect and maybe say you're sorry, and these guys, all they wanted to do was avoid any kind of accountability. And they were willing, the lengths that they went to do that are shocking.
Yeah.
It was absolutely shocking. And so I don't know, like when you're trying to run from the truth, like when you go to such lengths to run from the truth, I don't know at what point that makes sense to someone. Like, when did we lose this moral compass of just like, hey, this is what happened and I got to stand by my actions. And I think that's ties into some of the problems we're dealing with.
Yeah.
Society,
I guess what I'm wondering is, did any of the defenses that you saw, did any of that gain traction with the focus groups and then, cause you to, do
Great.
something different at trial?
Great question. Great question. We breathe life into the other side's cases when we legitimize it by responding to it.
Right.
And I'll have to say, had I not focus grouped the living daylights out of this case, I would have spent a lot of time defending those claims and being defensive. But what I learned from the focus groups is that people were not going to blame my client because he's a normal person. He might have some flaws. And so instead I owned it. I embraced it. I was like, this is who my guy is.
Yeah.
He's, I think in closing argument, I'm like, he's not someone that they would respect, but this is who he is. Because they spent such an inordinate amount of time attacking my client that the jurors' questions were like, it got to the point where, I don't know if I was reading the tea leaves, I felt like the jurors were like, why are you guys making a big deal out of this? Move on.
Yeah.
So when you say the jurors' questions, does the jury get to ask questions to the witnesses in Washington? Okay.
Yes.
What kind of questions were you hearing?
Well, like the one I'm thinking of that I remember, it was something to the effect of, the supposed drinking and drug problem. Is it hard alcohol or is it beer?
Right.
And it was after their expert had just gone on and by the way, they were violating, they intentionally violate motions in limine, which, a motion in limine is a court ruling.
Right.
This stuff has nothing to do with the trial. It doesn't go to my client's damages. It doesn't go to whether they're responsible or not. The only purpose of it is to infuriate or inflame the passion and prejudice. And this defense lawyer, and I knew they were going to do it. I'm not, I'm used to seeing it, but they went so far over the top of bringing in stuff that the court had ruled was not going to come in because they just wanted to have the jury hate my client. And what happened was what I knew was going to happen in the focus groups is that people don't care.
Right.
We all have flaws.
Well, and especially if you're going to put so much blame on the victim, on Mr. Tisdale, at the same time not accepting responsibility for the multiple things that they didn't do right, which you did a great job of sort of walking the jury through, all here, that they have programs set up or are supposed to for, robbery deterrence, and that they basically didn't give any training to their clerk. And to the point, one thing that we didn't mention was that after the clerk tells your client, Mr. Tisdale, to call 911, and Mr. Tisdale steps out of the store, the clerk locked him out of the store, which to me is like, hey buddy, you're on your own now. We're not gonna help protect you at all.
This case needed closure for the clerk as well, because you ever hit a dog or a bird and you're driving and your heart just, oh, yeah, because you had a hand in fate that was really kind of yucky, And so this clerk, he's a good guy. He was doing the best he could, but he was a defendant, his actions were holding the company. But you know what? This guy didn't know any better, and he was put in a dangerous spot. And because he didn't have the training, because the store was dangerous, he did what he needed to do to survive. And he didn't know that his actions made it dangerous, not just for him, the clerk, but he imperiled my client. And now that poor guy has to live with that every day for the rest of his life. And you're right. When my guy's on the phone, and he's sticking his head out, like, what's going on? And he steps out, the clerk locked him outside in the dark with a deadly, criminal with a deadly weapon. and didn't think twice about it. And his intention for telling my guy to call 911 was to make my guy a threat to the robber.
Oh,
To scare him.
yeah.
You know? And so that's why training matters.
Yeah.
I wanted to touch on, you had sent us the transcripts from the trial, and I didn't get to read all of them. But I was looking for your opening and your close. But when I opened one of the first transcripts chronologically, it was a conversation with the court that you and opposing counsel were having before openings had started. And it looked like you all had maybe had an agreement to exchange PowerPoints or something like that. But you got theirs like super late. It had all this stuff in it that hadn't or was
had been ruled out.
Yeah. Or wasn't ever going to get into evidence. And, reading it, we've all sort of been there in terms of that sort of last minute trial stuff, but this certainly seemed to be a lot. It seemed to be more important because, or at least potentially more important because of the logistics of a COVID trial and what's happening with the PowerPoint. But can you just talk a little bit about, especially for newer lawyers, what went down and just how you kind of kept your cool and approached it?
Yeah. I moved for a mistrial 2 or 3 times in this trial, and that was one of them because it was so dirty. It was so intentional by the defense lawyers. And this was a 3-week trial. It took me 2.5 days to put my case on. Okay. I did my whole case in 2.5 days. And that's something we should talk about, of brevity, get to the point, how do you do that? But these defense lawyers consistently broke and violated the court rules. And so opening PowerPoints are a big deal. And if you're going to go try a case, now you may not want them to see yours. Like if for me, I'm a kind of like, what you get is what you see. I don't play games. I try to meet people like honestly. I give you the benefit of the doubt. We're going to be we're trial lawyers. Let's just do this ethically, morally, and let's do our jobs. Yeah. Right is right, wrong is wrong. If I'm wrong, I can live with it. Well, a lot of people engage in gamesmanship, and that was obviously their tactic. And so the judge ordered these people to give me their PowerPoint well in advance. And I got it at like midnight the night before, like at some crazy hour. And I just assumed they weren't going to do a PowerPoint, but they push the limits and they know that they can probably get away with it. And so I bring it to the court's attention. I'm like, here's the PowerPoint. And of course, the PowerPoint was, I don't even know what to call it other than like an insult to the rules of evidence, an attack on the court's rulings, a blatant and shameless attempt to smear my client and make him look like a horrible person. Like the stuff they put in the PowerPoint was geared for one purpose, to inflame the jury, to hate my client, to make him look like a horrible person. And so I bring it to the court's attention, like, here we are again, the umpteenth. By the way, I've been practicing law for 25 years and I've never brought a motion for sanctions until this trial because of things like this. And so I bring it to the court's attention, move for a mistrial, it's denied. And they go and they show these slides that talk about all the things that they were not allowed to talk about, like sexuality, drug use, arrests, like his income, all the things that I had moved to keep out because it wasn't worth trying to explain it or talk about it because they were going to misuse it. And they just left it up there. And so to answer your question, what do you do when another lawyer is playing games and trying to throw you off your center? I'm glad that I have a lot of experience. I'm glad that I had the faith in the jury. I'm glad that I had the faith in myself and that I had focus grouped it. And you have to be able to compartmentalize. In life, sometimes we're really good at it, almost too good at compartmentalizing. Like we can be dealing with crisis after crisis and just simply not deal with it because we'll put it in a box, put it aside, and then never ever deal with it, But in trial, you have to remember it's a shared experience. And by that, I mean, the jury's experience is not yours. And so I had to deal with this and get up and give an opening statement as soon as the court rules on this stuff. And I'm furious. I'm outraged. I'm upset.
Right.
But that's not you got to remember that that's not the jury's experience. And so when you bring that energy, so they do that so that you look ugly with the jury, because how do you recover from that?
Right.
You know what I mean? So if you bring that energy to a jury and I give my opening statement and I'm upset and my blood pressure is high and my chi is like, I'm up in the throat and I'm like, so I'm aware, I'm spatially aware of the emotional temperature of the room. What's the atmosphere? And I don't want to change that. I want to be below it. And so I got to meet people where they are. And that's tough to do. Like intellectually, I think you guys know what I'm talking about. But practically, when you're in that moment and you have to control your emotions, which is kind of like the meaning of life, and sometimes we're not on top of them and they explode, you're in trouble.
Yeah.
Yeah. I mean, that's tough. And that's also the kind of thing that like, okay, I can cool down from it, but I need more than 5 minutes. Like, you know, and for you, you had to immediately, I mean, the judge was like, I'm bringing the jury out. Like,
Yeah. We went from this gamesmanship, trickery, and frankly, I believe unethical. I believe it was unethical, done for one purpose, to throw me off guard. And they pushed the trial out. I had an expert from your neck of the woods, the East Coast, out there all week, just waiting, you know, like a brain doctor. You're talking about, you know, like $50,000 type stuff, just sitting there. And the delays that were obviously thrown out there to throw me off of my trial schedule and the choreographing of witnesses, right? I'm dealing with all of that at once. And it was gamesmanship so they could hide from the truth.
Yeah.
And so part of me kind of relished in it because I knew that I was prepared. I knew what I needed to do. And that's the best that they had. I knew that they were in trouble.
Right. Yeah.
That is a good way to look at it. Well, I had a question on a different topic, Steve. I don't know if it sounded like you were about to ask something.
No, I was actually going to move us towards talking about damages, but what was your?
Well, I do want to touch on. I want to talk about damages, but I wanted to make sure, Eric, that we gave you a chance. You mentioned how you had planned out this trial to do it quickly, to try your case quickly, and I'm hoping you can give some practice pointers to our listeners on that, how you do that.
So as a plaintiff's lawyer, we walk a really fine line. And I shaved off a lot of witnesses because I just want to get out of my case intact. And I don't want to overtry a case. And so I gave a 20-minute opening statement on a case that is supremely complicated. And I guess we all know that in this day and age, attention spans are short. There's divided attention going on. And we have to recognize that as a lawyer, like we have to go out there and entertain. We have to go out there and connect with people at a level where the attention is sinking in. And if you can't recognize that you droning on and on and on about things that don't matter to the listener is counterproductive to your case, I don't think I need to say much more than that. The hard part about this is that we as lawyers are betrayed by our intelligence and the information that we have. And so we feel like, you know, we carry a responsibility that is crippling. You know, like when you're responsible for someone's life, and if we don't do a good job, you know, they could be out on the streets and suffer and not, or die in prison. That's hard to do. And so we put so much pressure on ourselves and we try so hard that I got to get this out. And what we have to do instead, I think, is be able to yes, we got to do the lawyer stuff, but at the end of it all, there's a message and there's a truth, and you have to identify it so that it's coming from the heart. And I don't know how to teach that or explain it other than it takes a lot of work, and preparation and practice.
It is something that is so hard to master because, we put so much time and effort into these cases and for our clients that you think you want to make sure that tell the whole story, give them every piece of evidence that's going to support it. But it's so important. Do you have a certain methodology that you go about to, narrow down your evidence? Like, one witness per point or two witnesses per point or something like that?
Great question. I believe in momentum and kind of like an energy. And I love cross-examination. I was a criminal defense lawyer and I still am. It's my passion, actually. I love criminal law. I know how to cross-examine and I know how to tell a story through cross-examination.
Right.
And so there's a price that we pay when we put a witness on. There's a great book, I think it's called Sponsorship Theory or How to Win Trials. And the bottom line is any lawyer who puts a witness on the stand is being docked credibility points because of course that person's going to advance your case. So what happens if you can use the other side's witness to prove your case?
Yeah.
And so I'll withhold like massive chunks of evidence so that I'm continually ending the day. By the way, like how do you end a day in trial? Like that's a whole nother like hour we could talk about. But
yeah.
I'm in my mind, I'm thinking, how can I build momentum, choreographing witnesses, and then using their witnesses to not just build momentum, but like go over the top with it so that they are destroyed. I mean, just absolutely destroyed. And so my method of building that energy, I think, is again, going back to preparation and focus grouping and realizing what matters to the common person, like the juror. Like a sample jury, what matters to them? Because we are so in love with our cases and we get blinded and we have these blind spots of what matters and what doesn't matter. And that's like the kiss of death. Like when we don't know what really is important because everything is.
Yeah, that's right. That's right. I do want to hear your thoughts on how you start and end each day of trial, because I think when lawyers are putting together their order of proof or, how they're going to do this, I mean, how you start off the day and then how you end the day are just so important because, it's the first thing the jury hears when they're coming back in and then the last thing they hear before they go home and spend time with their family. So tell us some of your thoughts on that.
Well, first of all, on a disputed liability case, I think the most important thing is you got to deal with liability. But back up a little bit. So we give opening statements. The defense lawyer gives their opening statement, and then we get up and put on the first witness. I think you should know your opponent's case so well that you know their opening statement and what's the one witness that you can put up right away that debunks everything they said. So I'll put some thought into that. And so in this case, it was the clerk. The clerk, these guys are saying, well, we trained him. He did everything right. And I deposed the clerk. I knew what he was going to say. So let's get him up on the stand. Let's see what he says. And he just completely undercut their whole opening statement. And then I put on the manager. And then I did my liability expert so that he had credibility. If I had gone straight with my liability, he's a paid guy. So I used witnesses to build the credibility of my people. Then I went into, then at that point I had liability. Oh, I played some corporate rep dep stuff, like unbelievable, crazy stuff that this corporation, man, I hope multiple people got fired. Like, I mean that so that this company is like finally like worried about something other than how much money they can make selling, whatever they sell. And then on lay witnesses to kind of give credibility to, I called the treating doctor first, because what do they don't have a dog in them. They don't care. They just want to speak the truth. And then some lay witnesses. And then on damages, this was the most complicated damages kind of scenario in this case was a seizure disorder, which is a consequence of the brain injury. So I chose to call that witness last because it was the most complicated and required a little bit of understanding of the brain and why it happened, so that the jury had some basic knowledge of brain injury so I could go into the more specific.
Yeah. Did you, I wasn't sure, I saw a comment about this in your closing, but I wasn't sure what to make of it. Was your client there the whole time, or he wasn't there?
Never showed up.
Okay.
Okay. But I thought you did say you put on some of his testimony. Was that through deposition or something?
They played his deposition.
Okay.
So talk about that, because that how you handle that, how you get the jury to sort of feel for a guy that they're not seeing.
Because I feel I love my client, and I mean, I unless you can emote and connect with the human suffering of your client, you shouldn't get up there and try the case. Having said that, I wasn't like focusing on my client, but when I did, like if you read the opening statement, you saw, like I talked for damages on maybe a minute.
Right.
Like what more do you need to say when someone's so messed up like this?
Right.
But putting my client up to talk about, oh, my life sucks and I have headaches and I can't remember anything and I'm miserable nonstop. I don't see that as being particularly great evidence. Having his friends and his employers talk about how he has changed. Oh, that's all of a sudden okay. But jury, we know that our human capacity to sympathize and connect and to love is kind of like lost. There's compassion fatigue, and we just don't care. And so I'm not too worried about whether my client gets up and wants to talk about what they're going through.
Did you prepare the jury for that during voir dire or anything? Or
no, I had 20 minutes.
Right. For your voir dire was 20 minutes?
Yeah, I had 20 minutes to pick a jury.
Well, I think that could be a really cool lesson. When you only have 20 minutes, what is the main thing you focus on?
Yeah, I mean, for those of you who haven't tried a case, I mean, that's what makes this extraordinary. Because I think of jury selection, when we walk as plaintiffs lawyers, when you get up in front of a group of strangers, you're not exactly a credible person. We've lost these trials before it started because of this misperception of what it is. And so I think of jury selection as I just want to respect you guys. I want to hear what you have to say. And, if I can just model good human behavior and show that I value you as a person, will you just value me and give me a chance? Like, I think if I've done that, I'm going to be all right. Having said that, like, there's core principles we have to talk about: money for justice, burden of proof. Here, we've got some criminal that whacks my guy in the head with a baseball bat. Why should we sue a company, right? What is that? How can they be responsible for that? Oh, and by the way, if my client never you guys are going to be here for 3 weeks and my client never shows up, how would you feel about that? And to answer your question, I didn't have time to talk about it, because I basically had time to say, hello, my name's Eric. How do you feel about money and for justice? And it was done. There was no for cause. I was stuck with the first people that came in, of which half of them thought lawsuits are driven by greed and that verdicts are too high.
Yeah. We didn't ask you this. Pierce County, Washington, which is, I think that's the Tacoma area, right? Is that, what's that like as far as venues go?
It's really favorable. It's phenomenal. It is phenomenal. But I've been burned by alternates. And in this case, some of the people that I knew were just like, I was never going to reach them, got sick or couldn't stay awake, and, kind of it solved itself. And so, more like open-minded people slipped in, and the whole dynamic. So group dynamics is a fascinating thing.
Yeah.
And that's, for another day, but you can change the dynamic of a group of 12 with one person.
So did you for voir dire, was that in person? I know that the trial was in person, the jury was there. Was jury selection in person too?
Yeah, the jurors had masks on. We were allowed to take our masks off when we spoke.
Okay, I was just curious, because we've had some in Georgia where the trial was in person, the jury was there in person, but the jury selection was virtual by Zoom. So I don't know what I would prefer, but I haven't had to do either. I wouldn't know if I would prefer the jury selection by Zoom where I could see people's faces, but maybe whatever weird is happening with their background or
My
see
thoughts on
them through
this,
masks.
and I was given all sorts of suggestions. My thoughts on it, like, why do I care? They have to deal with it. I have to deal with it. My worrying about it isn't going to change it. I'm just going to be me. And by the way, someone's eyes tell a big story.
Yeah.
And if you're focusing from the heart and you're communicating and looking people in the eye, I mean, what more do you really need? And I understand the 60 facial muscles, and you can try and read what it is, but you know what? The truth is the truth. Either you're prepared or you're not. They have to deal with it as well. And let's just go at it. Let's just do our best job and see what happens. And so I didn't worry about any of that stuff. I didn't care.
I think it's really interesting that you have this, it seems like you have a lot of faith in your jury that if you are genuine and honest and yourself, that you will get the same back.
Yes.
And I don't know if I have that.
Well, think about this. People are always getting in fights and they don't know why. It's because they're bringing this anger and this kind of intensity to them. And if you don't trust a group of people, because we've been, you guys know how hard it is to get up in front of a jury and lose, and we get rejected. That's past trauma, you guys. We're bringing that with us, of rejection and failure. Yeah. And when we get up in front of a jury and that's our baggage that we're bringing, and we're looking at this beautiful group of people and like, you guys, I don't trust you. I've been hurt too many times doing this. Well, they can pick up on that.
Right.
And remember, that's not the share. I'm going to say it again. It's a shared experience. You're bringing that shit with you, and you need to check it at the door.
Yeah.
Because these are good people who showed up for a civic duty to do a job.
Yeah.
And they want to do a job, and you got to be open to that, give them the benefit of the doubt. Even the people that think lawsuits are driven by greed and frivolous, because are they okay with a company that will blatantly ignore the law so they can make more money? I hope not.
Right. Yeah. So I wanted to ask one more question before we turn to damages, because we do need to spend some time talking about your damages case here. But did either side call the assailant, Mr. Sablin?
No.
Okay. Was that because, and the defense didn't try and call him for any reason to try and point the finger at him or put, blame on him somehow?
No, he was never identified as a witness. And under the law, if they'd done that, I probably would have liked it. Another example of anything they will do to avoid the truth, and their duty.
Yeah.
Well, let's talk about the damages and how you presented this to the jury. So as Yvonne pointed out at the beginning, your client was hit several times on the head, in the face, and in the neck, and on his back by a baseball bat, to the point where he lost consciousness and had a fractured skull, had a subdural hematoma, and then suffered bleeding on his frontal lobe and a tremendous damage to his right temporal lobe. But at the same time, he could hold a conversation. If you met him, or I'm guessing if you met him, you might think that you could have a sort of regular conversation with him. So talk about, when you have somebody like that and you're building your case for, a traumatic brain injury, how you build that up, and then how you get the jury to where they were, obviously awarded a significant, very large verdict.
Yeah.
I'm going to add one other thing. Tell me if I'm wrong, but I think you didn't put in your medical bills and you didn't put in any lost wages. Is that right? And your medical bills were $400,000 or so?
Yeah.
Okay. Yeah.
Yeah. I left behind on the order of 1.5, pushing 2 million in specials. And so if you're going to talk about the value and the meaning of human life, and so all right, so there's many ways you can ask for money. We all know the closing arguments, a jet pilot is flying through the sky and the plane is going to crash. And do they stay in the plane to try and save it, even if it's a $2 billion plane, or do they hit the eject button and get out and save their life? Or, the Louvre is burning down and the Mona Lisa's in there and there's a baby sitting next to it, right? What do you grab? And another one could be, there's endless ways to talk about like the tangible, fixed black letter. Here's what the value of money is, and contrast that with the value of a human life. I truly do believe that our value of money is so ass backwards and nonsensical in this day and age that until we as lawyers really believe that a human life is worth as much as anything that you can put on as a tangible figure, then we're doing ourselves a disfavor. And I view myself as a social engineer to be a force for like humanity, for the soul searching, like spiritual missions to make the world a better place. And if that is my belief, and that's my value of this person's life, then why wouldn't I compare, so my closing argument was twofold. It was the salary of sports athletes, of how much they make a year, which is hundreds of millions of dollars. Then if that's the case, how can we not say this man's life isn't the equivalent? How is it not? I don't understand. Why, what's so controversial about this? Why is that hard? It's not to me. And so that's just what I happen to think. I love this guy. I think that he's suffering horribly and no one would want his life. And so they owe it to him. They took it. Now they have to pay for it.
And I think we forgot to point it out, but he was 31 years old when this happened.
Yeah.
Okay.
Yeah. He has a horrible existence, horrible existence. His chances of suicide, early death, and his suffering like nonstop, it's unspeakable.
Yeah. Yeah. I found that very, one of the things that, in addition to talking about, helping the jury think about damages, one of the things that you mentioned that resonated with me, and I would have to think resonated with the jury, is you just spoke a little bit about this relationship with pain that he was going to have. And I feel like everybody, for people who are unfortunate enough to deal with chronic pain, they get that right away. But I think even people who have just dealt with pain at one point or another, I don't know, I thought that was a very kind of a different way to put it, but a very moving way to talk about it.
My fiance came up with that.
Oh, that's great.
I thought that was great.
It's brilliant. It's freaking, it's beautiful. It's 100% original, a non-lawyer created the closing argument. And it's the truth.
Yeah.
Well, and I liked one of the terms that you used was you called it, you had sort of this endless loop of pain and then it was a cycle of sorry. I thought that was just a really good way of expressing it.
Yeah. Thank you. I'll
make
sure.
Yeah. Yeah, it was. Yes, please do. Cause it was great. And I thought it was especially good coming off of, there was a moment when I was reading this transcript, Steve, I don't know if you thought about this, but so much of the time when we're talking about how these cases are defended, we're talking about how they just wouldn't own anything. They wouldn't accept anything. And if they had, how much heat that would have taken out of the case. And there was a moment where I was like, well, maybe they're going to do it, where he was, I can't remember if it was the opening or closing, but where opposing counsel was like, nobody's disputing the injuries. But then I was like,
and then they disputed every part of it. Yeah.
Yes, you are. But that was, we didn't spend a lot of time talking about it, but in addition to the defenses of sort of blaming Mr. Tisdale for what he did and blaming, sort of the criminal, even though they weren't, I guess, under the law really supposed to do it, talking about sort of it being like an intervening cause. But a lot of the other things they did was basically say his seizures were bad because he wasn't taking his medication and saying,
or seeing his doctors.
Victim blaming. They wanted to blame the victim. And
right.
That's like, haven't we done this before?
Yeah. One thing I was really interested in talking about is they seem to make a big point of the fact that he was a marijuana user. And first of all, we know that if you suffer from pain, marijuana can be very medicinal. But the other thing I'm wondering about is, I mean, you're in Washington State. This isn't Georgia, where marijuana is legal. So I'm wondering, how does that go over with the jury? The fact that somebody is a marijuana user.
You'd have to ask the defense lawyer what,
Right.
because I focus group this stuff to see, how stuff resonated, and blaming a guy. By the way, it's FDA approved for treatment of seizures. And you just want to attack a guy because he smokes weed.
Funny thing about that, Ivana, is the one use you can use THC in Georgia for is seizures.
Oh,
so,
really?
I mean, so it's the one loophole we have here.
Look, I think that, I mean, like, as much games as the defense lawyers tried to play to throw me off, I'm very grateful for their trial strategy.
Yeah.
And I mean that from the bottom of my heart. Like, thank you guys. You put me through hell and you did a lot of things that I'm still scratching my head on, but like attacking this guy because he smokes weed.
Yeah.
Or that he has a hard time remembering to take his pills because, his head is bashed in, and you just want to blame him for everything. I think there's a book like Debunking Nuclear Verdicts or something like that. That'd be a good book to.
Yeah. No, I mean, I can, there's a lawyer here in Savannah, who's a defense lawyer, and he was the master of keeping verdicts down. And the reason why is because he would just come in, accept responsibility, and then just say that he just needed the jury's help in determining what the correct value is, and I mean, but would accept everything else, and had such a good way with the jury. And he would get hit with verdicts, but he never got hit with what I would call, really huge, significant verdicts.
Were you able to talk to the jury after this case?
Yeah, I did.
Did they have anything that, kind of to say that was, whether it was about the defense strategy or just in general that was different or additional to what you had learned from the focus groups?
Yeah, frankly, I don't really remember too much about that because, when the verdict came in, my reaction was this was a group of people that gutted it out in a couple of days. We were in the mid 80s, and we even closed court one day because the conditions were so.
I saw the judge mention something about the heat there.
Yeah. My gut impression was this was a thoughtful, thorough group of people that, saw the difference between right and wrong, lying and honesty. And they didn't buy into, right, the portrayal of my client and how great and honorable this business is and how they've done everything right. And so then they had a credibility issue. You know what I mean? Like, so that really is what it comes down to, is like credibility. Mm-hmm. And if the jury has to make a choice and they're given two radically opposite interpretations of the evidence, the law, and the damages, and they view one lawyer as credible and another lawyer is not credible, they have to decide.
Yeah.
And I think that's what happened, but I don't know that for sure.
Yeah.
Well, I mean, credibility is such an important point, and it's the most important thing at trial, in my opinion.
It is. It's your word and your bond, and that's where it just gets hard. We were talking about it earlier, where we might be the most credible person in the world, but we have a hard time breaking through, this front we want to put up, or these thoughts that we have. And so it's hard to get out our truth because intellectually we're struggling with what we have to do next, instead of being present with the jury of right here, right now. This is the message.
Yeah.
I want to make sure that we ask, just because, there's only so many of these, hopefully, that will happen. Given that this was a case that you tried during COVID, what kinds of, you were able to have an in-person jury. Were there any sort of COVID related issues that you had once everything got going, or it was kind of okay? I noticed that y'all sounded like everybody was in person, but then you were basically streaming the trial to allow for public access instead. Is that what was going on?
That's right.
Okay. Because I saw, it seemed like you obviously dealt with it well, but I think like 5 minutes into your opening, you had to stop because there were tech issues with that. But then did everything go pretty smoothly after that?
Yeah, so back up. So the Friday before trial starts, we come to do our tour and we want to use our technology and we have all this evidence loaded up and it's not compatible. And so our whole trial prep, everything from key documents, if you use trial pad,
Yeah.
and then our video choreographed that go well with my opening, we lost all of that and had to just do it with an Elmo and because we had to loop it through their Zoom portal.
Right.
And we weren't allowed to, I wanted to visit early. So that's a good practice pointer. One, bring motions and limine as soon as you can. And two, go do a tour as soon as you can and test your technology. I tried to do that, but it just wasn't going to happen because of COVID. And I told my team, I was like, you guys, we need to have 3 different options to try this case. Because if it's bad and it's going to happen, it's going to. And I have never done a PowerPoint presentation and I'm just old school.
Yeah.
I had probably close to 20 medical illustrations and a video reenactment, and I used one of them.
Wow.
And how expensive that stuff is.
Yeah.
Right.
Yeah.
And so and in this case had all of it. I used 2. I used the CT scan of the initial hospitalization and an MRI 3 years later that showed, the dead brain. And that was it.
Yeah.
And so you just have to be, you have to have a backup plan for if how you think it's going to go doesn't go.
Right. Absolutely.
Yeah. And have that sort of analog, old fashioned.
Yeah. If all else fails, know how to try a case with an Elmo, a Sharpie, and poster board.
Yeah.
Yeah.
Yep. That's right. That's right. And a flip chart. I love my flip charts.
Yeah, me too.
Wow.
Well, Eric, this has been just a great discussion. I'm wondering, is there anything else about the Tisdale versus Apro LLC case that you want to make sure our audience knows about that we haven't gotten a chance to talk about?
No, I mean, I guess what I would say is I was scared to death. When I sat down after the closing argument, I wanted to just break down into tears because I thought I had lost. And it took a lot of me pushing aside my fears and, my stuff that I carry so that I could be fully available for my client and to the court and above all else to this jury. Like we're simply like messengers of some story, some truth of justice. And we need to care and believe in what we do. And if we don't, get someone who does or go do something else.
Yeah.
Because it is important right now. Like we matter and what we are doing matters. And if you can trust, and this is what we were talking about earlier, if you can just believe that 12 good people have it within them to want to do better and make the world a better place, we have that opportunity as trial lawyers. Yeah. And that's a cool thing.
Absolutely. Well, tell what when you say you felt you had lost the case, what was driving that? Was that something you had picked up from what you thought you had picked up from the jury, or was it just something internal, or what do you think?
Yeah, I don't know. One is it's just I've lost cases I should have won, and I've won cases I never dreamed I could have won. And
yeah,
what I've learned is like if I feel great after a trial, that's like the worst feeling in the world. And when I feel like I screwed this up,
right.
And so that's what kind of gave me hope. But the jury, their questions had to do with liability.
Okay.
And that freaked me out. And I just wasn't thrilled to death with some of the stuff. It's just scary,
Yeah.
Like we were talking about earlier, you get rejected, you do the best you could do, and it doesn't matter because like you're stuck with a group of people that hate you or your case or the client or this concept of lawsuits.
Yeah.
And it's unknown.
Yeah.
It was a scary unknown.
Well, I mean, you did a fantastic job. It's obvious that you come to the courtroom with a lot of passion and a lot of empathy and caring, and those are all so important. For any lawyer that's representing a client, that they show their, how much they care and how much passion they have, because if the lawyer doesn't care about their client, then no jury is and no judges.
Amen.
So I want to let me just remind everybody, we've been talking about Tisdale versus Apro LLC that was tried in June of this year, 2021, in Pierce County, Washington, and it resulted in a $91 million verdict. And we have been talking to Eric Fong of Fong Law in Port Orchard, Washington, and you can look up Eric at ericfonglaw.com. Eric, thank you so much for your time.
Yeah, it's my pleasure. Thank you.